So what's the difference between a great sales pitch and a flat-out lie? In the world of contracts, that line is everything. One seals the deal, but the other, it can blow the whole thing up. Today, we're going to break down exactly what counts as contractual misrepresentation.
Okay, let's just jump right in with a big one. You're about to buy a business. The seller looks you in the eye and says it makes $1 million a year. Later, you find out it's only half that. Can you sue? Can you get out of the deal? Keep that question in your back pocket, because by the end of this, you're going to know the answer cold.
All right, so to figure this out, we've got to get our heads around a really key idea in law, which is that not every single claim a seller makes is a legally binding promise. The law actually expects a certain amount of, well, showmanship. Let's break down what that means.
Okay, picture this. You see an ad for a drink that says it'll make your eyes shine and you'll become enormously rich and powerful. You try it, and you're not suddenly a billionaire. Shocking. But could you actually sue the company? Yeah, of course not, right? This is a perfect example of what the law calls a puff. So what is a puff? Well, it's just that. It's over-the-top sales talk. It's so exaggerated or so vague that no reasonable person would ever take it as a literal statement of fact. The best coffee in the world, or this car will change your life. Those are puffs. You can't sue someone over them. But, and this is where it gets tricky, that line can get really blurry. Best TV in the world. Okay, that's clearly a puff. But what if the ad also claims it's very relaxing for the eyes? Now, if the seller is, say, an eye doctor presenting that as a scientific fact, it could cross the line from a boast into a specific, testable claim. See, context is everything.
And that idea of a testable claim leads us right to our next big hurdle, the huge difference between a fact and an opinion. For a statement to legally count as a misrepresentation, it pretty much always has to be a statement of fact.
Let's bring it back to that business sale we talked about. Saying annual sales are $1 million, well, that's a hard fact. If it's not true, you're in trouble. But what if the seller says sales are expected to be $1 million after a recent change? See the difference? That's a prediction. It's an opinion about the future, not a guarantee. And it's way, way harder to sue over.
And man, is phrasing powerful here. Look at this. A shop owner is asked what her shirts are made of. She's careful. She starts with, I do not know, and I think. So even though she ends up being wrong, they're not silk. Her answer is framed as her personal opinion, not a cold hard fact. That framing, that's what likely protects her.
Okay, so we've got our checklist going. We need a false statement, and it has to be a statement of fact. But there's one more giant hurdle. For a lie to actually matter in court, it has to be the very thing that made you say yes to the deal. In legal terms, this is called inducement. Check this out. Neil is selling shares in a mining company. He tells a potential buyer, Oscar, something very exciting and also very false. He says the company just struck gold. Seems like a clear-cut case of misrepresentation, right?
But here's the twist. Oscar, the buyer, he's no fool. He's an industry insider, and he knows for a fact that the company has not discovered gold. He buys the shares anyway, for his own reasons, completely ignoring Neil's lie. So, did the lie actually cause the sale?
And the answer is a big no. This is not a misrepresentation Oscar can sue over. And here's why. A false statement was made, sure, but it didn't induce the contract. Oscar wasn't tricked. He knew the truth. He didn't rely on the false statement, so he can't turn around and claim he was deceived. The bottom line is, you actually have to be fooled by the lie for it to count.
And, the same logic applies here. If a seller makes a mistake, say they tell you a product has a 2-year guarantee when it only has 1, but then they call you up to correct that mistake before you buy, well, that original lie is dead in the water. It can't induce you into the contract anymore.
Okay, we've covered a lot of ground here. Puffs, facts, opinions, inducement, it's a lot. So now let's just boil it all down into a super simple, practical checklist you can use for pretty much any situation.
So here it is. It really just comes down to these 3 things. 1, was there a false statement? 2, was it a statement of fact, not just a puff or an opinion? And 3, and this is the big one, did that statement actually cause you to sign the contract? If you can't check yes on all 3 of those boxes, you don't have a case for misrepresentation. It's that simple. So let me leave you with this. Think about the last big thing you bought, a car, a house, whatever. What did the salesperson tell you? Can you now see the difference? Can you spot the puffs that were just there to get you excited versus the hard facts you really based your decision on? Because honestly, knowing that difference, that's your best protection out there.